This is Bloomberg Law with June Grasso from Bloomberg Radio.
The Supreme Court stepped into the 2024 election this week, allowing Virginia to carry out a purge of residents from its voter rolls on the eve of the election without any explanation. The court's conservative justices overrode the decision of a federal court and a unanimous appeals court, which had found that the state's purge of about 1,600 voters violated federal law. The National Voter Registration Act prohibits systematic removals of voters in the 90 days before an election. Republican Virginia Governor Glenn Youngkin defended his order for the purge, which was issued on August 7th, the 90th day before the November 5th election, here on CNN.
Because it is done on an individualized basis, person by person, and because that person has in fact self-identified as a non-citizen, this is not subject to the 90-day blackout period, in my view.
The three liberal justices dissented. Joining me is elections law expert Richard Brofalt, a professor at Columbia Law School. Were you surprised that the Supreme Court intervened to reverse the Fourth Circuit and the district court judge?
Yes. Maybe I shouldn't have been, but yes, I was. So this case involves a state effort to purge people from the rolls on the claim that they're non-citizens. Non-citizens are not entitled to vote. It's illegal, and states are allowed to remove any non-citizens that are on the ballot. But there is a provision in federal law, National Voter Registration Act, that prohibits mass purges, so-called systematic purges, within 90 days before the election, because it makes it too difficult. People may be purged by mistake, and if it's a mass purge, it's actually difficult for people to be aware of that and to respond. And so that is illegal. But Virginia consciously adopted such a program. The governor issued an executive order to that effect, literally on the day that this so-called quiet or non-purge period was supposed to begin. And basically, it used some mix of DMV data and other databases to conclude that people were not citizens. DMV, when you get a driver's license, you may be asked whether or not you're a citizen. Some people check non-citizen by mistake. Some people check not a citizen because they are not a citizen when they get their driver's license, but some years later become naturalized as citizens. So the state, using that data and other data, went ahead and concluded that something like 1,600 people were not citizens and needed to be purged from the rolls. And that was challenged on the theory that it violated federal law, and also there was evidence that a number of these people who were purged were in fact citizens and were challenging those individuals.
So that challenge went up the chain, so to speak, to the federal district court and the appellate court. Tell us what happened there.
The federal district court in Virginia concluded that this was a pretty straightforward violation of federal law, that it was going on in this so-called quiet period, that it was a systematic removal effort, not based on individualized information about individual voters, but basically a massive database information that they were loading from one database to another. And the Fourth Circuit Court of Appeals agreed, rather refused to overturn the district court's injunction. The Court of Appeals basically said, yes, on the facts, it appears to us that this is a violation of federal law and it should be stopped. The Supreme Court rather quickly by, well, I'm tempted to say 6-3. We know that 3 liberal justices dissented because it was just an order. It's not clear that all 6 of the others agreed, but it looks like by pretty much a party line vote, without an opinion, basically reversed the Fourth Circuit and allowed this purge to go forth. The purge has actually stopped, but the 1,600 voters who were removed remain removed unless they can, as individuals, go in, and Virginia allows same-day registration, go in and prove that they are citizens and re-register and then vote.
Virginia made several arguments, and one was that the quiet period doesn't apply to non-citizens. Another was that courts shouldn't get involved because of what's known as the Purcell principle.
Right. So taking them in reverse order, the problem with the Purcell principle in this case is, the only basis for judicial intervention is that the state has violated the 90-day rule. So any effort to enforce the 90-day rule would occur within 90 days before the election. So it makes no sense to invoke the Purcell principle here. The only real question is, did the plaintiffs and the U.S. government, which also participated, move quickly once they became aware of what was going on? And the lower courts agreed that they did, that there was no delay. Once it became clear what the state was doing, the lawsuit was brought. In terms of whether or not the quiet period applies to removal of non-citizens, nothing in it indicates that it doesn't. In other words, the law is simply there to say that there should be no removals based on a system, no systematic removals. And it doesn't say no removals only for non-residency. It just says no removals that period. So there's nothing in the law that limits the grounds of ineligibility to something or other, such as to moving. And it does permit removals for death. So it's not quite clear what this law would be doing if it doesn't also apply to removals on a theory that the individual is not a citizen.
So, as you mentioned, we don't know why the justices voted as they did, but the three liberal justices made their public dissent clear. Mm-hmm. What does it tell you that this was down ideological lines?
It's very troubling. It's very troubling. The lower court decision was well-reasoned. The Court of Appeals agreed with it. And there is irreparable injury to those voters who might be eligible to vote who've been denied the right to vote. Now, some of them will be able to reestablish their eligibility because they can re-register in the coming days. So it's possible some of them will be back in. But, it takes time, it takes effort. It's quite possible some of them will not.
Although Virginia is not a battleground state, this was based on an order by the Republican governor and was backed at the Supreme Court by the country's 26 other Republican state attorneys general, the Republican National Committee, and several conservative groups. And it revolves around a flashpoint in Donald Trump's campaign,
yes,
which is that, there's widespread voting by non-citizens.
Right. And for years he's been making that argument. Even when he won in 2016, although he lost the popular vote, he says, well, I really won the popular vote because Hillary Clinton's numbers were inflated by all the non-citizens. There is absolutely no evidence of more than a minuscule number of non-citizens voting, and usually it's by mistake. It's illegal for non-citizens to vote. There are severe penalties. The number of non-citizens who are registered to vote or actually vote is absolutely minuscule. It is a non-fact. But it's been used so heavily by Republicans to try and undermine the legitimacy of the election. There is just no evidence that it occurs.
So do you think this lawsuit is to set the stage or the groundwork for contesting election results?
Yes, I think anything that raises the issue of non-citizens. Now, of course, Republicans won this lawsuit, so they won't be able to make this argument in Virginia now. But, it is an issue they've been raising all over the country. There was a similar dispute in Alabama where the federal district court ordered the governor to stop the purge program in Alabama and to undo it. And I think about 3,000 people had been removed from the rolls. And there was evidence that it's often by mistake. Again, they're using old databases. Sometimes it's the wrong person. There may be that the DMV numbers may indicate that this person with a certain name is a non-citizen. Somebody with the same name but a different person might be removed from the rolls because their matching is pretty basic. Basically, if you have the same first and last name as the person who's been identified as a non-citizen, you can be removed, and that's not so uncommon. And it also, again, using DMV data, since your driver's license can be good for 4 years or more, in that time, you could have naturalized from being a non-citizen to a citizen, but that naturalized person will be removed from the rolls. And so I think it's very much a way of keeping the issue alive and in front of people all the time. And indeed, people will think, there were 1,600 non-citizens voting in Virginia. But it's not clear that any of them were non-citizens. Certain names popped up on databases, and certainly there have been individual cases in the newspapers of people showing that they were not non-citizens, that they were citizens. Some citizens from birth and some naturalized citizens.
A lot of election experts have been saying that this year's election won't be a repeat of Bush v. Gore. The Supreme Court is unlikely to play a pivotal role. But does this decision indicate differently that the justices may get involved?
Yes, I don't know why you would think that the justices will be uninvolved. It will turn on what the issues are. And, I think Bush versus Gore was unusual in that the issue the Supreme Court dealt with was, in fact, a post-election issue. In other words, how to take care of a recount or how to take care of the counting of ballots in Florida where it wasn't completely clear how people had voted. And so that was an issue that could not have come up before the election. This time, I think they're deciding issues that could be relevant to the election beforehand, like this one. As for things after the election, there may still be things that come up. So it's hard to know. In some ways, you could argue that the decision earlier this year on Trump's immunity in some sense plays into the election, or he's getting on the ballot in the first place. So I don't understand the argument as to why anyone thinks that they would be more or less engaged than in 2000 or in 2020, where they did a bunch of things before the election, but not so much after the election.
Well, some people are pointing to those cases as an indication that the Supreme Court won't get involved, saying Donald Trump and his allies brought around 60 cases challenging the election in different ways, and the Supreme Court didn't take up any appeals.
Right. And including the original jurisdiction case that Texas brought against Pennsylvania to not count Pennsylvania's votes. Texas joined by 20 other Republican states. They didn't hear that. No, they stayed pretty much out of it after the election in 2020. But, the result in 2020 was pretty clear. It's hard to speculate about the Supreme Court, but this decision is not a great sign about the courts wanting to stay out of the election. This was an unnecessary decision. The law was pretty strongly on the side of the plaintiffs, the ones trying to stop the purge.
I do want to point out that on Tuesday, the Supreme Court did refuse to order the removal of Robert F. Kennedy Jr.'s name from presidential election ballots in Michigan and Wisconsin. The officials there said his request came too late under the laws of the two states where voting has already begun, and the Supreme Court didn't get involved.
Yeah, again, it's hard to figure out. It could be that maybe they want to be deferring to the states both ways. Refusing to order the removal is consistent with deferring to the state, and in this case, allowing the state to go forward with the purge is consistent with this deferring to the state. Maybe that's part of it, but I'm not even trying to attempt to say that there's a consistent logic.
It's hard to see it. A lot more election disputes to be resolved in the courts before the election, and I'm sure after the election as well. I'm glad I have you on speed dial, Rich. Thanks so much. That's Professor Richard Brafalt of Columbia Law School. Coming up next on the Bloomberg Law Show, the Philadelphia District Attorney sues Elon Musk over his $1 million a day giveaway to registered voters. But a judge in the battleground state ends a hearing without ruling on the request to block it. We'll tell you why. I'm June Grasso, and this is Bloomberg.
Every day from now until the election, we're giving out $1 million prize. That is, and all you have to do is sign a petition in support of the Constitution. It's very straightforward. You don't even have to vote. You don't have to vote. You just have to sign a petition saying you believe in the Constitution, which if you already believe in the Constitution, you're just signing something you already believe, and you can win $1 million. That's awesome.
But Elon Musk's $1 million a day voter sweepstakes doesn't seem to be the very straightforward proposition he's made it out to be. In order to enter, you must be registered to vote in one of 7 swing states. The Department of Justice has already warned Musk and his pro-Trump America PAC that his sweepstakes might violate federal law. And this week, Philadelphia District Attorney Larry Krasner sued Musk to stop the sweepstakes, saying it violates state lottery and consumer protection laws. Joining me is election law expert Douglas Spencer, a professor of law at the University of Colorado. Doug, tell us about the concerns about this sweepstakes.
The concern is that Elon Musk is using this lottery to encourage voter registration and voting, which on its face doesn't sound bad. We want more people to be registered and to vote. It does promote democracy. But there are federal laws that prevent people from paying or buying votes or paying people to register. And so there's been allegations that this scheme that he has created is doing just that, rewarding people for registering and then turning out to vote. The DA in Philadelphia is challenging this not just as a violation of these federal laws, but there's also some state laws about consumer protection and some other issues related to fraud. There is some sense of seriousness about the allegations that these federal laws are being violated, which is why the Department of Justice itself has commenced an investigation. They haven't charged him with any crimes, but they see some of the concerns about the way this program is being run, and they're investigating it.
So the DA in Philadelphia is going on a different kind of track. He's saying that this is a lottery, and as such, it's illegal in Pennsylvania because all lotteries have to be operated and administered by the state. So he's trying to get around the questions about federal law.
That sounds right. There's been a concern about operating a lottery, and whether it's been regulated or registered or, as you said, is operated by the state itself. And then also, at least in the statement that I read, it says that the lottery is being used to kind of lull or dupe Philadelphians and Pennsylvanians into giving away their personal data in exchange for money, which could be a violation of, a state false advertising or consumer protection law.
It would put it into a whole different sphere Because now he would have to follow all the rules for sweepstakes in Pennsylvania and the other swing states.
That's right. And what I don't know is in the state how to define a sweepstakes or a lottery, because nobody's buying a ticket or giving Musk any cash in order to enter the lottery. They're entering the lottery by signing a political petition. And so, there could be an argument that the act of signing a petition is different than buying a lottery ticket, which would distinguish this. And secondly, the act of signing a petition is a First Amendment protected act that buying a lottery ticket is not. And so you'd have to see the interaction of this regulation of lotteries to the First Amendment. But if the state defines sweepstakes as, entering yourself for a chance to win a large sum of money based on chance or random draw, then this lottery is in violation of that state law if he has not properly registered it or operating under those state regulations.
What's also interesting is that Musk said this is a random draw, but the Philadelphia DA says that appears false because multiple winners are people who have shown up at Trump rallies in Pennsylvania.
Correct. So that's an allegation that in order to prove it, if a judge is willing to take the case, then one element of a lawsuit is what's called discovery, and Elon Musk would have to provide some evidence of the selection mechanism to prove that the decisions were being made randomly. He'd have to have a record of the random number generation or a video of him pulling a ping pong ball out. And if he's not, then he's not actually running a lottery, in which case he's falsely advertising what he's actually doing. But at the same time, if he's not randomly choosing people, then what he's doing may not be a lottery, and that could cut in favor of Elon Musk, because then he can say, I'm not actually violating the state's prohibition because I'm just giving money away to the people that I want to give money away to.
Elon Musk obviously ignored the letter from the Justice Department. I mean, what's the import of that letter if it didn't stop the sweepstakes?
I think the letter from the Department of Justice does two things. One, it's a public statement that lets everyone in the public know that what Elon Musk is doing may be a violation of the law. But under the federal law, a violation is punishable by a fine up to $10,000 unless you are knowingly and willingly violating the law, in which case then you can serve jail time up to 5 years. So I think this letter from the DOJ puts the PAC on notice that you are doing something willfully and knowingly, even though we've told you that what you're doing risks a violation, so that the potential penalties, which will come after the election in any case, could be much more serious, trying to get them to change. I will note that the lottery has changed a little bit since the DOJ sent its letter. It used to expire, eligibility used to expire on midnight October 21st, which was the deadline for voter registration in Pennsylvania, which was a really strong signal that the motivation for this lottery was to pay people to register, not something else. That deadline has now changed until Election Day. So there was some recognition that that was a problem for them, and they have changed their tactics a little bit. So they are aware and they're reading these letters, and the question will be after the fact if there's any accountability.
I mean, they also changed it a little bit in that he said at one of the giveaways, one of the early ones, that all you have to do is now be a spokesperson for us. So sort of making it into a job offer, I guess?
Correct. He's trying lots of different ways. A judge will have to determine whether or not they think that's his true intent or not. If I pay you to register to vote, but I also say that you have to walk outside and breathe fresh air, and then you get the money, a judge will say, I know you told me that you're paying these people for breathing fresh air, but they also have to register. I just think that's a sham. So the question is, for somebody signing a petition that doesn't ask for anything, just says, I think the First and Second Amendment are important, is that something that's a legitimate petition, or do we think that Musk has been using it as a way to insulate himself from just out and out buying people to register to vote to make it look somewhat differently? And that will be a fact determination by a judge. If it gets to this litigation, they can look at emails between Musk and his PAC and other communications. They can make determinations based on public statements where America PAC says we want to get 1 million people registered to vote in these swing states, and they'll make a determination whether or not that was the intent of this lottery, even though there are facts that cut in different directions.
A lot of people are going to say this is a move by a Democratic DA against Musk, who's spending millions to get Trump elected.
I will say I think the political side of this is as important as the legal side. So the Department of Justice sending this letter does send a signal for voters, whether or not there's an actual violation, that what they're doing is a close violation of the law. And it could be the same for a district attorney who wants to make sure that this issue is framed in the press and in the political sphere as a legal mumbo-jumbo as opposed to a really exciting money giveaway. So there's a political aspect where bringing these charges changes the news coverage, changes the dynamics, and that may be just as important as any finding of guilt or innocence. And so that's not something that the lawyers like me can really comment on, whether that's the right way to go about it, but there's definitely a political angle to this.
Do you remember anything else like this in our history, any kind of giveaways like this?
Not in our modern history. Way back in the 17 and 1800s, this was before the ballot was secret, you'd have parties who would basically give away free booze to people. You'd vote for their party, you'd get whiskey, and it's very well known. And in part to avoid that kind of bribery, we adopted the secret ballot. And since then, nothing so open with payments. The parties, of course, are always trying to incentivize and motivate people to get out to vote. No lottery like this specifically from a wealthy billionaire either.
Thanks so much for joining me, Doug. That's Douglas Spencer, a professor of law at the University of Colorado. In just a few days, the case has bounced between state and federal court and back again. On Thursday, there was a hearing before a state court judge over Musk's motion to move the case to federal court. Bloomberg legal reporter Chris Dolmesh was at the hearing. So, Chris, the state judge did send the case over to federal court for a determination. Was there any discussion about the merits of the DA's lawsuit at the hearing?
Not specifically. Essentially, the DA's lawyer kind of launched into a bit of a soliloquy at some point on why, this shouldn't be removed to federal court. But the judge clearly, from the beginning, was not going to discuss the merits, just given it's kind of an automatic move when they remove it to federal court to at least have the federal judge determine as a threshold matter whether it's a matter of federal law.
So explain what their grounds are for removing this to federal court.
They're saying it's essentially a quintessential matter of election law, even though the DA's claims are essentially state law claims under Pennsylvania's lottery laws and consumer protection laws. So they say, look, this is an election dispute. It should be heard in federal court. They classify it as, he's trying to stage a show ahead of the election because he disagrees with Musk and trying to suppress his First Amendment rights.
And what's the response of the Philadelphia DA?
The DA says it's a state law case. He argued that while it touches on elements of federal election law, he argued that there are plenty of disputes that are related to the election that are heard in state court.
And Chris, we have seen this removal to federal court gambit before.
Yes. In many cases, it's a typical move. That's one of the reasons a lot of times when you see civil litigation between, say, corporations, a lot of the time they have an automatic clause that determines where the case will be heard if there is a dispute. That kind of eliminates that problem from the beginning.
This is a really serious issue, but from reading about it, it seemed to me like the hearing was pretty lighthearted.
Yeah, there were a lot of laughs. It was when the DA noted that Elon wasn't there and looked around the room, his lawyer said he can't just show up anywhere on, a moment's notice. And then the DA got up and said, well, as to that notion, he owns SpaceX. And then the judge kind of shot that down real quick. He's like, he can't land a rocket on top of the building. Let's be serious. And that got some laughs. The judge was clearly in a kind of jovial mood, one assumes, because he knew he wasn't going to have to do anything with it that day.
But now the ball is back in his court since the federal judge ruled that there was no issue of federal law involved in the case. We'll see what happens next. Thanks so much, Chris. That's Bloomberg legal reporter Chris Dolmesh. In other election news related to Pennsylvania, on Friday, the Supreme Court refused to intervene in a clash over provisional ballots in the state, rejecting a Republican emergency appeal. This leaves in place a state Supreme Court ruling that elections officials must count provisional ballots cast by voters whose mail-in ballots were rejected. Coming up, Sam Bankman-Fried's former lieutenant is the first to avoid prison in the FTX case. I'm June Grasso, and you're listening to Bloomberg.
I call it the wheel.
I don't think so.
What does it do?
It rolls.
Yeah, so does a bagel, okay? A bagel you can eat.
One of the worst ideas I've ever heard. Like I was saying, it's FTX.
It's a safe and easy way to get into crypto.
I don't think so. And I'm never wrong about this stuff. Never.
Remember back when FTX was the world's most popular cryptocurrency exchange with celebrity endorsements and a Super Bowl ad? Of course, that was before a gaping hole in customer deposits was exposed and FTX collapsed into bankruptcy. Federal indictments followed of founder Sam Bankman-Fried and his top executives. And it didn't take long for 3 of those executives to turn on Bankman-Fried, accepting plea deals in return for cooperating with prosecutors and testifying against him. Bankman-Fried is serving 25 years in prison after a jury found him guilty of the multi-billion-dollar fraud late last year. And now the 3 cooperators are learning what the consequences will be for them. In September, the prosecution's star witness, Caroline Ellison, a top executive and Bankman-Fried's on-again, off-again girlfriend, was sentenced to 2 years in prison. In October, Ryan Salome, one of Bankman-Fried's top lieutenants at FTX, who did not testify against him, was sentenced to 7.5 years in prison. But on Wednesday, former FTX chief engineer Nishad Singh walked out of Judge Lewis Kaplan's courtroom a free man. Why a get-out-of-jail-free card for Singh when Judge Kaplan sentenced the others to prison time? Here to explain is Bloomberg legal reporter Ava Benny Morrison, who covered Bankman-Fried's trial as well as Singh's sentencing. Ava, tell us a little about Singh.
Nishad Singh was one of 3 top executives at FTX who turned on Sam Bankman-Fried and signed up as cooperating witnesses to the government. They all testified at Bankman-Fried's fraud trial and eventually helped land his conviction. Bankman-Fried's currently serving 25 years in jail. And after his sentence, it was time for the cooperators to face their own punishment for their role in the collapse and the years-long fraud at FTX. Now, Nishad Singh turned up in court and we heard some pretty compelling arguments from his attorney about why he should avoid spending a day in prison. Only a couple of months ago, Caroline Ellison, the former CEO of Alameda Research, was sentenced to 2 years in jail. This is unusual. Most cooperators end up avoiding any jail time whatsoever. But fortunately for Nishad Singh, that was what happened. Judge Lewis Kaplan found that he deserved more cooperation credit than Caroline Ellison, and he was essentially less culpable in the fraud at FTX than Ellison.
Singh's lawyers apparently succeeded in setting him apart from Ellison and Gary Wang, who's yet to be sentenced. Was a factor also that Singh was involved in the fraud for a shorter period of time?
Judge Kaplan certainly seemed to focus on the amount of time Nishad Singh knew about the fraud. So Nishad, who was the chief engineer at FTX, only found out in September of 2022 that FTX had been sending customer funds, billions of dollars worth of customer funds to Alameda Research. In contrast, Caroline Ellison knew about this for years and was an accomplice to Sam Bankman-Fried. And Kaplan found that this certainly helped Nishad Singh's case. The fact that he only knew about it for a couple of months before FTX collapsed. Both the prosecution and the defense did admit, even when Nishad Singh found out about this massive fraud and that FTX couldn't afford to cover the hole in customer deposits, he continued to allow campaign donations to be made in his name and forged ahead with a purchase of a beautiful house in Washington State, something that his lawyer said he will forever be ashamed of.
$3.7 million house?
Yes, that's right. It was worth $3.7 million and he bought it with his friends as a place to go when he could relax and go on holidays. This was kind of the only luxury, maybe indulgent purchase that Nishad Singh had made when he was FTX. His lawyers, really stressed that he was a true believer in effective altruism, this philosophy that drew a lot of the FTX and Alameda Research folks together, this idea that you could earn a lot of money and give most of it away to make the world a better place. Nishad was very interested in charity. He'd been involved in giving away a lot of his earnings since he was in college. And his lawyers really tried to push that point that this was, a big purchase, but it didn't reflect his philosophy.
And he's been working all this time, unlike Caroline Ellison?
In Caroline Ellison's case, her lawyers had said that she was really struggling to find an employment. after the FTX collapse, mainly because of the reputational damage that came as being associated with FTX and Alameda Research. She had been working on writing a non-fiction book and a math book, but Nishad Singh had been lucky enough to find a job. He's been working as a software engineer for a firm in California since FTX collapsed. And he's also been volunteering at a homeless shelter not far from his house in the Bay Area. And at night, he's working on code for a affordable housing project. So this certainly went towards his argument for someone that is trying to build his life back up again and certainly doesn't have any interest in getting involved in a multi-billion-dollar fraud again.
Singh addressed the judge before he was sentenced, saying, quote, "I strayed so far from my values and words can't express how sorry I am." How did he come across?
Something that struck me about Nishad in court was that he remained very calm and very composed the entire time. When he got up to speak to Judge Kaplan, he approached the lectern with a piece of paper with his written words on it in his hand and said how remorseful he was and how gutted he was about the harm that he caused to so many innocent people. He spoke about wanting to prove to not only the judge but others that he was on the path to redemption and he wanted to do good and be a force for good in the world since being part of the calamity at FTX.
And what was the reaction when he learned that he wasn't going to have to go to prison?
I think the big question mark was whether Judge Kaplan was going to send Nishad to prison or save him from that, especially after the 2-year sentence that he handed to Caroline Ellison. So when he got to the pointy end of delivering his judgment, Nishad was standing between his two lawyers and Judge Kaplan said, "I order you to report to the Attorney General of the United States for time served." And at that point, Nishad Singh barely reacted. There was a very faint smile that came across his face, while his family, of which there were many seated in the public gallery behind him, all gasped. His fiancée, Claire, put her hand over her mouth. His mother kissed his fiancée on the cheek and they held hands, and you could see that how emotional that they were. They were crying, but you could just sense the kind of utter relief that rippled across the courtroom.
What seemed a little unusual is that the judge addressed Singh's parents and said, "I don't see anything you did wrong." Tell us what led to that.
That's right. As part of Singh's sentencing, his parents, along with his brother and other friends and former colleagues at FTX, submitted letters in support of him. And his parents' letters were pretty heartbreaking. They spoke about raising their son as best as they could, spoke about how intelligent and talented he was, and then discovering that he had been caught up in this fraud at FTX. And there were some pretty harrowing parts in there about the impact that the FTX collapse had on Nishad and how he had contemplated suicide in the weeks and months after FTX. His parents spoke about the impact on his mental health. And Nishad's lawyer actually made a point of saying, every time Nishad flew over from California to New York to meet with us at our offices, his father was there in the conference room sitting across from him, or his younger brother was there. So he had the unwavering support of his family, and that was very clear in the amount of people that turned up in the court. And the judge addressed that at the end of his sentence after he told Nishad that he wouldn't have to serve a day in jail. And he said, I'd like to just address Singh's parents on a personal note. And he said, "There is nothing I can see that you did wrong." And then he walked out of the courtroom. And I think that was quite an emotional moment in the courtroom, especially for Nishad's parents. You could see that they were, I think, quite receptive to what he said and almost grateful, because you can imagine the impact this has had on his family.
So this case is over. What's the next sentencing? Is it the final sentencing in this case?
Yes, we've got one final sentencing hearing left in this FTX saga, and that is of Gary Wang. Gary Wang was the co-founder at FTX. He helped build the exchange with Sam Bankman-Fried. He became the chief technology officer, and he was also a cooperating witness and gave testimony at Sam's trial. He's due to be sentenced at the end of November. So it'll be interesting to see where Judge Kaplan puts him on the culpability scale, because he knew about the fraud at FTX and Alameda Research a little bit earlier than Nishad Singh did, but from the evidence that we heard at trial, he wasn't as deeply involved as Caroline Ellison was.
So the judge will have to balance all that out. I know you'll be there for that, Ava. Thanks so much for bringing us inside the courtroom. That's Bloomberg legal reporter Ava Benny Morrison. And that's it for this edition of the Bloomberg Law Podcast. Remember, you can always get the latest legal news by subscribing and listening to the show on Apple Podcasts, Spotify, and at Bloomberg.com/podcast/law. I'm June Grasso, and this is Bloomberg.